Need to introduce you to our first annual Judicial Dialogues on Health and the Law event. I am extremely honored to have all these justices from Latin America and the Caribbean, which will be introduced by our co-director, Silvia Serrano Guzman and Oscar Cabrera. Thank you, Dean Trainer, for having us and being here today. Without further ado, I will let you give some opening remarks. We remind you that questions, you were left with this little card so you can write them, and our colleagues will be picking them up. For people on Zoom, there's also interpretation, as well as for people in the room for English, Spanish, and Portuguese. Thank you.
Thank you very much, Fernanda. I'm Bill Trainer, the Executive Vice President and Dean of Georgetown Law, and it's my privilege to welcome you to the Law Center. And I'm just thrilled that we are able to come together for this extraordinarily important event. This marks the first event in the series Judicial Dialogues on Health and the Law, which we hope to become an annual event. And I'd like to start by offering a special thank you to our esteemed High Court justices for honoring us. It really is remarkable to have. I'd like a round of applause for our justices. This is the most justices we've ever had at Georgetown Law, so it's a red letter day for us. I'd also like to thank our host, the O'Neill Institute Center for Health and Human Rights, for organizing this inaugural event. We're here today to discuss the judiciary's role in protecting health rights across Latin America and the Caribbean. A high court plays a pivotal role in establishing, and I'm quoting, health as a public good, unquote, by interpreting and upholding the right to health as a fundamental human right. This includes various dimensions of health, such as prevention, healthcare provision, and individual autonomy as fundamental rights, thereby impacting the overall well-being of a society through its judicial rulings that encompass various aspects of health. As we look at the many global health challenges facing us today, it's clear that health and human rights have never been a more urgent priority. In recognition of the need for passionate, ready, and capable legal advocates, Georgetown Law has made a significant investment in the study of health and human rights law and advocacy. Georgetown Law has a long and distinguished history of being a gathering place for judicial dialogue. Our guests today further contribute to the school's tradition of welcoming esteemed jurists from around the world to Washington, D.C. to engage with our community and to contribute to our greater understanding of a variety of pressing issues. And it's also extremely important that these discussions bridge across countries and regions so that we can learn from one another. We at Georgetown truly have a global campus, and in moments like this, we're reminded of how fortunate we are to be part of a community that engages in such impactful work around the world. So we're honored that this conference will continue Georgetown Law's tradition to create space for open dialogue on health and law. This series will include discussions on the regulation of private actors, equality, non-discrimination and intersectionality, sexual and reproductive health, and environmental protection. Having these conversations are also important as they help reinforce the judiciary's continued responsibility to evolve in response to new and emerging health challenges. It's critical that we build a network of judicial cooperation, fostering dialogue on shared challenges and solutions in safeguarding health and human rights, particularly the importance of transnational learning. So it's our privilege to have you all here today, and I look forward to this discussion and to many discussions in the years ahead. So it's now my pleasure to hand the stage to Silvia Serrano and Oscar Cabrera, co-directors of the Center for Health and Human Rights of the O'Neill Institute for National and Global Health Law. Thank you.
Thank you very much for your remarks, Dean Trainer. And we're going to start hearing from our faculty director, Michelle Goodwin. She's going to present a short video, also introducing this event.
Congratulations, Oscar. Congratulations, Sylvia. Welcome to our justices, to Washington, D.C., to Georgetown University. Welcome to the Georgetown University Law Center and, of course, our O'Neill Institute. I'm Michelle Goodwin, and I had the pleasure of being with many of you yesterday. I'm the co-faculty director of our O'Neill Institute for National and Global Health Law. I wish that I could be with you in person. I am in Milan for a convening sponsored by the Soros Foundation. But here's what I'd like to share with you. You are thinking about and convening on one of the most important issues globally, and that is, how do we protect and preserve the public's health? Is there a right to health care? And if so, from where does that right spring? Is it a human right? Is it a constitutional right? Is it something that is governed by lawmakers, local policymakers, legislators, members of the parliament? Is it something that justices weigh in on? And from where does that authority spring? Who protects the public and its health when legislators do not get to it quickly enough? How do we advance the advocacy of those who are in the trenches fighting to make sure that the most vulnerable amongst us have adequate access to health care? And what does that really mean, having access to health care? For so many communities, and we can think about this during times of national and global health crisis, COVID-19 brings that to mind. Having access to water, having access to electricity, having access to basic sanitation. Are those healthcare issues? Many amongst you would say yes, because in order to have robust healthcare, it requires basics that may not appear to be health related. You'll unpack these issues and many more, and we look forward to you joining us in years into the future. At this first annual convening, it is so important to bring together in a safe, secure environment ideas about how to protect, how to promote, how to preserve the public's health. And crucial to that is how to promote and protect for the most vulnerable amongst us, those who often lack a political voice, lack economic wealth, may lack education, but nonetheless deserve all of the fruits of what it means to be a citizen, and not just the citizen of a nation, a citizen of the world, something that each of us is destined to and for. And again, I celebrate you, Sylvia, and I celebrate you, Oscar, and in deep gratitude to the justices who are convened. I look forward to being with you next year as we roll up our sleeves and continue to tackle these very important issues.
Okay, so we're going to start here from all of these justices that are here with us today for 15 minutes each, and then we will have a Q&A session. So we will start with Justice Natalia Angel Cabo from the Constitutional Court of Colombia.
Well, good afternoon, everyone. I'm absolutely thrilled to be here. We have spent 2 days discussing very important issues with wonderful judges from Latin America, which is really nice to be gathering even in Washington with justices of Latin America. I have to thank Oscar and Sylvia for the invitation. In this conference, about any topic regarding sex. And I must say that an open was a little bit regarding court because Colombia has the highest litigation on health in the world. So as you can see, we can just pick and choose any topic about health, the right to health. But talking with Oscar, we decided to present to you what I think is the most important case concerning the health system in Colombia, which is Judgment T-760 of 2008. It is a very relevant judgment that even a professor from Harvard University referred to the ruling as I quote, the most sweeping and significant judgment regarding the right to health in the world. So I don't know if that it's too much fuss, but it's a very, very ambitious ruling. So I can do this. Okay. So I will divide my presentation in three parts. First, I will explain how cases reached the Colombian court and present some of the debates that took place in Colombia before Judgment 7060 of 2008. Second, I will illustrate how the court responded to those problems and share with you some data of the outcomes of this case, which basically is one of the key issues since one of the debates is whether these cases can produce social change. And finally, I will share with you some brief thoughts about the ruling. So let's begin by relevant features of the Colombian Constitutional Court and the Constitution of Colombia. In 1991, Colombia enacted a new constitution. It is a broad text that introduced several changes to the previous constitution that was from 1886. Among other things, the Constitution characterized the nation as a social state of law, and the social part is important, not socialist, but social, adopted a comprehensive Bill of Rights, including social and economic and cultural rights, and established new mechanisms for easy access to courts. One of these innovations was the tutela action, which is undoubtedly, I think, one of the greatest innovations of this constitution. The tutela is a legal remedy for the protection of fundamental rights. It is an informal action that can be brought by any citizens when their fundamental rights are violated or threatened by the action or omission of any public authority, and even by private actors in some specific circumstances. All judges in the countries are tutela judges, and they must decide the tutela actions within 10 days. So ultimately, all the tutela actions reach the court, and the court decides which to address. Just to give you an idea, we receive 80,000 cases a month, and we only select 40, or between 35 and 40, but we receive 80,000 a month. So many of the discussions in Colombia regarding the role of judges in health have arisen from tutela cases. But this discussion has evolved over time, so I'm just gonna give you a brief overview of that. Second, in order to understand Judgment 760, it is important to understand a little bit about the health system in Colombia. By the time that the Constitution was enacted, almost at the same time was enacted a very comprehensive law on health, which is called Law 100 of 1993. So some important features of this law is that it's a mixed system. So it established a complex model that includes private agents responsible of health insurance. And so they are called EPS, which is health promotion entities, public and private institutions responding of providing medical services, which in Spanish will be IPS, and the state is responsible for regulating and supervising the system. There's also an important feature also to understand these tutelas is that at the time, the law divided the system into two tiers. One is the contributive system and the subsidiary system. One basically is the plan for employees or individuals earning more than 2 minimum salaries. And the other one is a subsidized plan for those outside the formal labor market. At the time, it was kind of even, but then it changed, and we definitely have much more people at the subsidized system than on the contributive system, so that you can understand the challenges of who will finance the system. So basically, I'm having a problem. So basically, there's at the beginning of the work of the court, meaning in the 90s, in the early 90s, was kind of an opening period. And so one of the first debate that the Colombian Constitutional Court, that was also created by the Constitution of 1991, one of the first questions that the court had to address was whether socioeconomic rights could be enforced by courts. And it is not surprising, because in a country with such a lack of resources and with big inequalities, well, people approach the court not to basically ask, or not mainly to ask for fundamental rights of first generation of rights, but socioeconomic rights. So right from the start, the court was asked the question of whether judges, through tutela action, could enforce socioeconomic rights. Trial judges said, like, the first response was not. The Constitution said that the tutela is basically reserved for fundamental rights. And the trial judges understood fundamental rights, meaning first generation of rights, liberty, formal equality, and so forth. But instead, the court, right from 1992, so like really from the start, said that it was not the case, that the Constitution cannot be read as establishing a category of rights, that courts, that there was not such a clear difference between first generation of rights and second generation of rights, or fundamental rights, and then the nature of rights would be determined by the material content and the relationship to the constitutional principles and values. So based on this reasoning, the court opened the door for adjudicating socioeconomic rights based first on the principle of equality. So we have a very, in the 1992, a very big case about HIV and retrovirals that were not included in the list of medicines and treatments that the system would provide. Then another way that opened the door for socioeconomic right adjudication was through a doctrine that is called minimum vita, which was a German theory that we incorporated in Colombia, saying that people should have as a fundamental right a minimum standard of living. So we developed that as a fundamental right. And also we developed a doctrine that was called the connectivity doctrine, meaning that through tutela, you can ask for the guarantee of socioeconomic rights if the absence of the guarantee of such right could threaten undisputable fundamental rights. So for example, health was basically the case, because if you are not provided one treatment and your life is in danger, then you could ask for this in tutela. So at the beginning, so it opened the door, but it was not, again, if you can change, it was not necessarily, sorry, I'm having problem with this. So you could, in the back, yeah. So at the beginning, it was not shocking. It did not come as a shock that the court opened this door. And the court started to basically grant some cases of health, but there were not too many. The problem came in 1999 and in the aftermath of that, because in that period, based on many things, regulatory actions, economic crisis, the basically amount of tutela actions really increased dramatically. So can you change the following? So we had in 1991, the court received 21,313 tutelas, but in 2001, we received 22,000 tutelas, and this started to grow and grow and grow until I'm gonna show you a more figure, a recent figure. We all have almost 1 million tutela actions to this day that we have addressed regarding to health. So now it started to become a problem, because now this is judges on individual basis granting medicines, treatments, and of course the impact on the health system. So you cannot plan a health system if you have individual cases addressed in this way. But at the beginning, let's say judges were not that sensible about those issues until really it became a very debated topic in the country. Just give me. So basically, Judgment T-76 of 2008 became a really interesting case because it tried to respond to these problems of individual litigation, but the individual litigation was basically illustrating problems, structural problems within the public system. The problem was not the tutela. The problem was the problem that the tutela was addressing. But definitely to respond by individual cases was a really problematic thing. So this judgment basically brought together 22 different cases, but to illustrate the problems that were affecting the health system. And basically so one of the the good things that this judgment did was to provide an overview of which were the structural problems of the health system. It also basically reaffirmed the justiciability of health by saying, let's not discuss whether you could go to the tutela to ask for health, because health is a fundamental right. So that just the saying is a fundamental right, and let's not discuss this. It was a really strong thing. But it also basically, it's the epiphany of what we call dialogical justice. What it says is, I'm looking at structural problems, very, very hard structural problems. I am not the one to resolve that problem. It's the government and the legislature, but I'm gonna provide a roadmap and send it back to you so that you can resolve those problems. But I am going to monitoring what you are going to do. So along with the orders of this judgment, the court basically created a monitoring chamber, a following chamber that's still up to date. There's in the court, we monitoring the compliance and the fulfillment of this case. So, and it has really provided a forum for dialogue among different stakeholders within the health system. So the aftermath has had positive things, this judgment. So very briefly, based on this case, the government of the time presented to the legislature a comprehensive legislative a law, which is a very special one, a statutory law, trying to solve some regulatory deficiencies, and it has solved some of them. And so that was a very important outcome. So legislator really responded to what the court did. I'm not gonna go into the details because I don't have too much time, but for example, there was these two systems, the one of the contributory tier and the subsidiary tier. They were very unequal, because if you were not in the formal market, you were receiving half of the benefits as if you were in the formal market. And the court unified, ordered to unify those, and the law did. And there's a lot of progress made towards universal coverage. Delays in payments for medication not covered by the basics of the health plan have also improved. And all patients now have access to rights, to the rights charter that stipulates the conditions of the service provided. But of course, there's also a lot of limitation, and I'm just gonna tell some briefly. One of the aims of this judgment was to stop health litigation in the country. And if you can see, that has not stopped. It really decreased in the first year, but then again, we are really seeing a high increase of litigation on the right to health, and mainly on the same topics that in 2008 we were addressing, that are really problems of the of the of the system as a whole. So basically, I'm just bringing this in order to show that so courts can make contributions to the health system, and adjudication of socioeconomic rights, I think, is important in order to address and put into the spotlights problem with the public system, but still it's a limited avenue to solve the many problems that we have in the country. Thank you very much.
Thank you very much, Justice Natalia Angel Cabo from the Constitutional Court of Colombia. And now we're going to hear from Justice Amaury Reyes Torres from the Constitutional Tribunal of the Dominican Republic.
Hello, good afternoon. Thank you so much to O'Neill Center for the invitation to Georgetown University School of Law to have us here and to discuss things that we like to talk about, and from our standpoint, trying to contribute to better solutions in terms of fundamental rights and human rights as a whole, and especially the right to health. I want to thank also Sylvia and Oscar, Fernanda, Natalie, all the team, and the friends from Reorganization as well. And to my wife, that she doesn't want to be here, but she's here. Hello, honey. Okay, so one aspect of being here and discussing all of this about rights and constitutional courts is just to take a look to our own experiences and to see what are the differences. And one of the main aspects of this is since we're here in the United States, we tend to look a lot what's going on in the United States, especially with the US Supreme Court. It is important to just extract some differences. For example, in the Dominican Republic, we have a constitutional court separate from the Supreme Court. We have the Supreme Court, but we decided after 2010 to strip the Supreme Court with the constitutional issues jurisdiction and create a constitutional court. And the constitutional court has original jurisdiction. We take cases to review whether a legislative act or some act of the municipal authorities or some other kind of legal act of broad applications, like a regulation from the executive or any public administration, just to see whether or not it's constitutional. Or we also try to resolve the conflicts between the entities of the local state and the national government. But also we have a interesting proceeding. We have a preemptive judicial review to review whether the international treaties that will be ratified by the Dominican Republic is, prior to that ratification, is constitutional or not. But also we have a jurisdictional review if in the ordinary matters of criminal, labor law, administrative law, and family law, and so on, reaches the Supreme Court, and after that, it has some constitutional issues that were not resolved within the judicial system or with the Supreme Court, they can come to us, so we have a narrow review of the constitutional issues that might arise from those decisions or from those cases. And also we have a review jurisdiction of the amparo or tutela, or that is a special writ, speedy remedy in order to reivindicate or to protect fundamental rights. And also I will take this chance to say that in Latin America, especially in the Dominican Republic, unlike the US, we don't have that distinction between constitutional rights and fundamental rights. Fundamental rights and constitutional rights are pretty much the same, as long the rights are in the Constitution. Unlike the Supreme Court, unlike the US constitutional law, which the fundamental rights are the rights that are incorporated through the substantive due process of the 14th Amendment, or the constitutional rights that are enshrined in the amendments to the American Constitution. So that's basically an overview of what we do in the Dominican Republic with the Constitutional Court. So we have a really expanded jurisdiction. So the right to health. The right to health in the Dominican Republic, we follow the same tradition in Latin America. For us, it's a constitutional fundamental right. And the discussion about whether you can file for lawsuits in order to protect a social economic right like the right to health is, I don't want to say that it's meaningless, but it doesn't represent an obstacle in order to make that right effective. So in the case of the Dominican Republic, the right to health is specially enshrined in the Constitution, but also it can be protected through another rights. So there is a relationship of interdependence between the right to health and the right to life, the right to a healthy environment, the right to dignity, the right to personal integrity, and some other rights that can be into place, especially the right to privacy. So another thing about this is, what is the fundamental with the right to health? What is the basis on the graded foundation? Here, the foundation of the right is who is the person that owes the protection. It can be the individuals, the private sector, or the private individuals, which is another difference from the United States constitutional system. For us, it doesn't matter if it's the government, local or national government, or any private citizen. They are the person who owes to the holder of the rights. So the Constitution also allows people just to sue another one, so can have some kind of a protection. And it's interesting because these are the basis that is more complicated. For example, in the judgment 3118, it's a good example of how a private citizen tried to sue a pharmaceutical in order to make available once again a medicine that was taken out of the market. And that person used to argue that this medication for arthritis doesn't exist anymore in the market. I have no way to try to get that medicine for my treatment. So this pharmaceutical needs to, regardless the cost of the business decision, needs to bring back the medicine in order for me to obtain that and undergo a treatment. The court didn't comply with the request. It rejected the petition, but it allows the foundation for future litigation. And it says that if a person can prove that the exclusion or the unavailability of that medication is unjustified and violates some of the fundamental rights, but also the medication cannot be replaced with some other generic or some other medication, and actually the person itself cannot obtain any remedy for that treatment, so the court can order the company to produce that medication regardless of the price. In this case, the court didn't order to produce the medication because that person has double nationality and didn't prove that it was without any economic means to acquire the medication. But it's interesting because the court says that the companies of pharmaceuticals, only because they have business interests or because there is no good business side to produce the medication, it doesn't matter if there is an urgent situation that requires them to produce the medication. And also this takes us to the mandatory vaccination issue. Under the judgment 441 from 2022, we can see here what is the main foundation for private actors to comply with health regulations and also for private individuals to comply with mandatory vaccinations. Here, the Constitutional Court says that since we are living in that democratic state that is based on the same foundation of the social democratic rule of law, like Justice Natalia Angel just advancing her presentation, every person has a solidarity commandment, because we are living in this society and you are willing to participate in the society and enjoy the rights of the society, you also have obligation towards the majority. So that's why you need to submit yourself to vaccination if it's required by law. But some of the things also it's very good to take into account, especially regarding insurance company. We relied on insurance, one another people more than other, and not necessarily because we want to, but sometimes because we have to. So we had this case, Judgment 213 from 2019, which this is very interesting. This is a private insurance that rejected the claim of the parents of a little boy that had this weird and dangerous sickness. Unless this person wasn't taken to Miami to undergo to a procedure, he will just die in a matter of days. So they just proceed with a urgent amparo, urgent remedy to protect the fundamental right to health. And the judge below in the first instance court granted the writ, and the company went to the constitutional court, and we dismissed the review. Why? Because we thought that in that case it was an underage person with a really, really complicated and life-threatening situation. And number three, regardless that it was a sickness that it was way known and way before the engagement of the insurance contract, it didn't matter because all those things taken it as a whole, the insurance company need to cover that because it will be way worse and the damage will be worse if the insurance company didn't cover that procedure. So that is very interesting that cracks or breaks with a sole economic ambitions or economic driven insurance business and say you need to cover this because of this situation. This doesn't mean that you need to go now and file a lawsuit against insurance company. No, it means that in given circumstances in which the person is in a situation, a vulnerable situation, it cannot commit itself to the proceeding because it doesn't have the ways to do it and only can do that through means of insurance company. Insurance company needs to come forward because of that solidarity requirement under the right to health in our constitution. Also, we have a very interesting decision from last year in which the right to health is mingled with some other constitutional rights, in this case, the objection, objeción de conciencia, or the conscious objection. In this case, we have parents from the Jehovah's Witnesses congregation. Their kid needed a transfusion, but the parents declined to submit their kid to that proceedings because it goes against to their holy, sincere beliefs. The attorney, the prosecutor in that area of Santiago in Dominican Republic said that it was important for the underage boy to undergo to that proceeding and get the transfusion done, unless it will die in a matter of days. So he decided to file a lawsuit in behalf of the kid against the parents and against the hospital, so they can be forced to submit the kid to the transfusion proceedings. And in the court of first instance, it was granted the amparo, and then we got to the constitutional court. We applied a remedy that is very known in the United States. It's called repetition yet evading review. The case came too late to the constitutional court, but we decided the case anyways, and we just said that in those cases in which the life of the underage person is in the middle, it trumps the sincerely held beliefs of the religion's parents. So in that case, that was interesting how to see the conflict between constitutional rights in that case. But also the court, regardless the decisions that notwithstanding the decisions that I already mentioned from the Constitutional Court, the last judgment that I said, it was judgment 1078 from 2023. But there is an important judgment that I want to bring is 111 from 2019. And it's very important judgment because you might say, okay, but these courts from the Latin America, from the Dominican Republic is very active in trying to protect rights that has some economic complications. And that is actually true in a way, but it doesn't mean that we're doing this just in order to affect the whole system. And actually there is a case, the Social Security issue that in Dominican Republic is a constitutional right there is a right to social security, it has this relationship with right to health. And in a case, the court actually granted a petition to protect the right to health and the right to social security, but analyzing priorly that by giving the pension to this person that was suffering for a sickness that didn't allow that person to continue working and to have a minimal living standard, it didn't mean that it will just crack financially the system, meaning that the court take into account whether or not granting a petition for protecting the right to health or the social security rights, it will not crack economically the whole system. So that is a way to see how these balancing interests were taken into account. Finally, I want to stress the relationship between the water and the right to health. Unlike the Constitutional Court of Ecuador that Justice Andrade will talk about it, I think, in a minute, the right to health in the Dominican Republic is an implicit constitutional right. We have an obligation on the state to provide access to water, but there is no constitutional right explicitly in the Constitution. But in the decision 482 from 2016, the Constitutional Court says that it is a right. And because it's that right and the time is up, that's the court said to the person that blocked the access to water because he didn't pay for the fees of the condominium. And the court says you cannot impede or block arbitrarily the access to water because that will just damage the right to health and the right to a life with dignity and with a minimum standard of living. So thank you so much, and thank you for allowing me to wrap some minutes. Well, thank you. Thank you.
Thank you very much, Justice Reyes. And now I'm going to give the floor to Justice Catalina Lagos from the Constitutional Tribunal of Chile.
Hi, good afternoon. I'm going to speak in Spanish for your sake and mine. And so now it's the perfect time to go and get your translation devices if you want one. Quiero agradecer la invitación del O'Neill Institute. Es un honor y un placer estar acá. En estos breves 15 minutos que tengo, me gustaría dar cuenta de alguna particularidad del sistema chileno. Nuestras jurisdicciones constitucionales son diversas y por lo mismo son distintas las problemáticas que enfrentamos. En particular, hoy día me gustaría hacer la constatación de que frente a la justicia constitucional chilena, frente al Tribunal Constitucional chileno, se ha invocado la libertad de conciencia para obtener la declaración de inconstitucionalidad de políticas públicas en materia de salud. Voy a mencionar 3 casos relativos al derecho a la salud, el primero a la salud reproductiva, el segundo a la salud sexual y el tercero a la salud pública en términos generales. Y voy a referirme también a un caso que más bien se relaciona con el derecho a la educación, pero van a ver que se vincula con uno de estos casos y da cuenta de los desafíos que tenemos nosotros como Tribunal Constitucional para enfrentar justamente la invocación de la libertad de conciencia en relación con las políticas públicas en materia de salud. El primer caso que les voy a comentar es un requerimiento de inconstitucionalidad que le llegó al tribunal respecto de un proyecto de ley. En Chile es posible que alguna de las 2 cámaras del Congreso Nacional o el presidente de la República o un grupo de parlamentarios, que es el caso, acudan al Tribunal Constitucional para que una parte de la ley o toda una ley, ¿cierto?, sea declarada inconstitucional por infringir alguna norma de la Constitución. En este caso, se trata del proyecto de ley de interrupción voluntaria del embarazo en 3 causales, riesgo de vida de la mujer, inviabilidad fetal letal y la causal de violación. ¿Y qué es lo que se pide declarar inconstitucional en virtud de la libertad de conciencia? La regulación legal que estaba dispuesta respecto de la objeción de conciencia de los profesionales de la salud que tenían que practicar estas interrupciones del embarazo. La regulación que disponía que el personal profesional que estuviera dentro del pabellón y tuviera que practicar la interrupción del embarazo, podían objetar de conciencia y se determinaba además que la objeción de conciencia es de carácter personal y en ningún caso puede ser invocada por una institución. Eso fue cuestionado que solamente beneficiara a los profesionales de la salud y no al personal técnico que estaba dentro del pabellón. Y también se cuestionó dos aspectos más de la regulación, que eran limitaciones para el ejercicio de la objeción de conciencia en términos de cuando estuviera en riesgo de vida de la madre y la atención médica fuera impostergable, no se podía objetar de conciencia. Y en el caso de la violación, se establecía la limitación relativa a que no podía el médico excusarse si es que estaba pronto a cumplirse el plazo para ejercer esa causal, porque la única causal que tiene plazo en nuestro ordenamiento jurídico para ser ejercida es la de violación. Hasta cierto número de semanas, dependiendo si se trata de una mujer o de una niña. ¿Qué es lo que decidió el Tribunal Constitucional en este caso? Decidió acoger parcialmente esta impugnación de constitucionalidad y señaló que efectivamente era inconstitucional limitarlo a los profesionales de salud, era inconstitucional restringir la objeción de conciencia solo a las personas naturales, por lo tanto se declara inconstitucional en esa frase en que decía la objeción de conciencia es de carácter personal y en ningún caso puede ser invocada por una institución, en ningún caso se declaró inconstitucional, quedando la figura de manera tal que abarcaba a personas naturales y instituciones o personas jurídicas. Y también se declaró inconstitucional la imposibilidad de objetar de conciencia, aun cuando en la causal de violación estuviera por cumplirse el plazo para poder acceder a ella. ¿Qué se razona para justificar esto? Se señala que la objeción de conciencia es un derecho constitucional, que es una manifestación de la libertad de conciencia y que debe entenderse amparada por la dignidad de las personas, tanto individualmente como proyectada en asociación con otras personas jurídicas, cuando se negaren a realizar ciertas actuaciones por razones éticas, morales, religiosas, profesionales o de otra señalada relevancia. Y se argumenta también que las personas no pueden, y la ley no puede disponer de las personas como un medio, y en ese sentido no podía obligarse a las personas enajenar sus propias convicciones para efectos de satisfacer las necesidades de otros. Por supuesto, este fallo de mayoría no fue una votación unánime, hubo un voto de minoría, una disidencia, en la que se cuestionan, por una parte, que la libertad de conciencia devenga necesariamente, la protección de esa libertad de conciencia tenga como correlato inmediato u obligatorio la objeción de conciencia, cuestionan que no se hace cargo el razonamiento del voto de mayoría de los distintos elementos que caracterizan la figura de la objeción de conciencia, entre ellos que la objeción de conciencia no puede afectar a otros y señalan que la objeción de conciencia es una dimensión individual de la conciencia y que no puede ser trasladada de modo irreflexivo a las personas jurídicas. Es interesante que en el voto de mayoría la Corte señala que pese a que la Corte Interamericana ha interpretado que la objeción de conciencia no puede ser institucional, a propósito de la interpretación de las normas constitucionales de nuestro ordenamiento jurídico, el Tribunal Constitucional se va a apartar de la jurisprudencia de la Corte. Y eso es interesante porque normalmente el Tribunal Constitucional sigue la jurisprudencia de la Corte Interamericana y acoge los estándares que va consagrando en su sentencia. Luego, ese es un primer caso. Entonces vemos que ahí la libertad de conciencia inconstitucionaliza parcialmente algunos aspectos de una política pública de salud, particularmente el acceso, ¿cierto? En el acceso o restringiendo el acceso a una prestación de salud vinculada a la interrupción voluntaria del embarazo. Un segundo caso que me pareció interesante transmitirles y que justamente consiste en la invocación de la libertad de conciencia para efectos de inconstitucionalizar una política pública en materia de salud, tiene que ver con la ley que regulaba las garantías, o era una ley integral en materia de derechos de la niñez. Había una norma específica que regulaba, el artículo 41 de la ley, que regulaba el deber del Estado de garantizar en el ámbito de sus competencias y de acuerdo a sus atribuciones, una educación sexual y afectiva integral de carácter laico y no sexista. En este caso, nuevamente, era un proyecto de ley, un grupo de parlamentarios recurrió argumentando la inconstitucionalidad de el apelativo de laico y no sexista de la política de educación sexual y afectiva, porque atentaría contra la libertad de conciencia y la libertad religiosa que asegura la Constitución, porque el mandato que se estaría imponiendo a los órganos del Estado tendría como consecuencia una exclusión de otras visiones y de otras aproximaciones, ¿cierto?, particularmente religiosas. Y además vinculaban esta libertad de conciencia con el derecho preferente que tienen los padres a educar a sus hijos, que está reconocido en nuestro texto constitucional, porque justamente uno de los medios en que los padres manifiestan sus creencias es precisamente a través de la educación. Y que este precepto en cuestión, al referirse a una educación sexual y afectiva integral de carácter laico y no sexista, impediría compatibilizar creencias religiosas y morales de los padres en relación con la educación sexual y afectiva de sus hijos. ¿Qué es lo que señaló el tribunal en su voto de mayoría? Declaró inconstitucional justamente la referencia al carácter laico no sexista de la educación sexual y afectiva integral. Argumentó que es una expresión innovadora por parte del legislador y que su falta de precisión, su indeterminación, no asegura un debido respeto por toda expresión religiosa y en general por toda expresión valórica, por cuanto la expresión no sexista no es neutral, pero tampoco profundiza mucho en aquello, y luego mandata al Estado a garantizar de una manera única, señala que el mandato al Estado de garantizar de una manera única y determinada la educación sexual y afectiva excluye otras cosmovisiones en la materia y constriñe a los establecimientos educacionales y por consecuencia limita la libertad de los padres para elegir el tipo de educación y de establecimiento educacional que se ajuste a sus propias creencias valóricas y religiosas. De modo tal que se concluye señalando que es una interferencia excesiva del Estado en espacios de libertad y autonomía que están constitucionalmente protegidos. Con posterioridad, y aquí está la sentencia que se refiere en términos generales a la educación no sexista, se establece en el proyecto de ley que estatuye medidas para prevenir, sancionar y erradicar la violencia contra las mujeres en razón de su género. Había una disposición, el artículo 12, que establecía el deber por parte de los establecimientos educacionales reconocidos por el Estado de promover una educación no sexista y con igualdad de género. Y aquí, que es en términos más amplios, pero uno podría eventualmente o no, eso va a depender del legislador, considerar que la educación sexual y afectiva sí está incluida en el término global educación. Eso es algo que vamos a tener que ver cómo se va a interpretar por los intérpretes legítimos. Se planteó la misma argumentación que en el requerimiento anterior. El requerimiento anterior ya tiene algunos años, esto fue este año, y este año cambia el criterio del Tribunal Constitucional. Y el Tribunal Constitucional rechaza la impugnación y se señala que hay que descartar la vulneración del artículo 19, número 6, que es el que establece la libertad de conciencia y religiosa, y se señala que la libertad de conciencia no asegura el derecho a difundir creencias discriminatorias y que, por ende, tampoco es necesario acudir en este caso a una teoría de la colisión de derechos o a un ejercicio que que hoy día está en desuso en Chile, pero que se utilizaba, que era la jerarquización de derechos, para comprender, dice el tribunal, la orden de promover una educación no sexista en términos de que no vulnere la garantía de la libertad de conciencia y de culto. Y finalmente, un último caso que le tocó conocer al Tribunal Constitucional, ahora no en control preventivo de las leyes, sino que en una gestión judicial concreta se solicita la inaplicabilidad por inconstitucionalidad, es decir, no aplicar y declarar inconstitucional para el caso concreto, dos normas del Código Sanitario que se refieren a la vacunación obligatoria. Una pareja de padres solicita que se declare inconstitucional los dos artículos del Código Sanitario que obligan a la vacunación de enfermedades transmisibles, piden que se declare inconstitucional para que se les exima a propósito de que ese tratamiento médico que impone el Estado, según los requirentes, es contradictorio con el sistema de creencias al que adscriben los padres, que es el de la medicina antroposófica, y que ello atentaría contra su libertad de conciencia y su autonomía. ¿Qué es lo que dice acá el Tribunal Constitucional? Señala en votación unánime que se rechazaba el requerimiento, que la vacunación obligatoria se ajusta al principio de proporcionalidad, se realiza el test de ponderación o de proporcionalidad, y que en definitiva, luego de la realización del test, la medida persigue un fin legítimo, es adecuada y necesaria y proporcional en sentido estricto. Y se señala que la libertad de conciencia de las personas no puede ser invocada para oponerse a cualquier regulación legal que éstas consideren contrarias a sus creencias, ya que eso echaría por tierra el Estado de Derecho, y menos cuando tal oposición se da en un ámbito que involucra a terceros. Y ahí se recoge algo que mencionaba el voto de disidencia de la primera sentencia que les mencioné. Voy a cerrar planteando algunos desafíos, porque obviamente hay una constatación acá de que se utiliza, se esgrime, ¿cierto?, el derecho a la libertad de conciencia para declarar la inconstitucionalidad de aspectos de políticas públicas en materia de salud. Pero tenemos ciertos desafíos, porque a propósito de las resoluciones y las decisiones del Tribunal Constitucional vemos que no son del todo coherentes. Eso se explica en parte por el cambio en la integración del Tribunal Constitucional. El Tribunal Constitucional de Chile no tiene sistema de precedentes, pero nosotros entendemos, y siempre lo hemos hecho así, que si tenemos un cambio de estándar, ¿cierto?, explicamos el estándar anterior y el cambio de estándar. Pero tenemos en esta materia en particular un desafío todavía pendiente de dar cuenta cómo hay un cambio de criterio, ¿cierto?, y cómo se llegan a conclusiones diversas en casos que podrían tener bastantes similitudes. Y finalmente, plantear el desafío en términos de la metodología, porque el último caso utiliza el juicio de ponderación o el test de proporcionalidad para resolver el caso, y sería interesante ver cómo se hubiesen resuelto los otros casos si es que se hubiese seguido el mismo mecanismo, ¿cierto?, o la misma metodología analítica, poniendo, ¿cierto?, sobre la balanza los derechos que entran en colisión y no solamente resolviendo en abstracto respecto del alcance y sentido de uno de ellos. Muchas gracias.
Thank you, Justice Lagos. And now we're going to hear from Justice Alfredo Gutierrez Ortiz Mena from the Supreme Court of Mexico.
First of all, I want to thank the O'Neill Center for organizing this very interesting event. It has been extremely interesting with respect to health law. I was told I could speak about anything, and I misunderstood, and I thought I had to speak about everything. So bear with me. I'm going to go over 100 years of case law development in Mexico on health law. 1917, I kid you not, 1917, the Mexican Constitution was enacted, and it was the first constitution in the world to establish social rights. One of those social rights, Article 123, established constitutionalized labor rights. And within labor rights, you had the right to Social Security. So health rights in Mexico began as a right to access to Social Security with respect to health in 1917. Now, if we look at the development from 1917 to 1994, most of the cases have to do with the building of institutions. The Social Security Institute was built in 1943, was created in 1943. The Social Security Institute for Government Workers was created in 1959, and the Social Security Institute for the Military was created in 1974. Most of the case law from 1917 to about 1994 have to do with a great deference to the legislative branch in the building of these institutions. Most of the cases have to do with the issues of employer payments, whether they are taxes, broad powers to the executive branch for collecting Social Security payments. But we see very little development in this period with respect to human rights and the right to health in human rights. 3 developments occurred along the way that permitted the courts to have a more active role and to really start taking health rights seriously. 1983, Article 4 of the Constitution was amended to establish that the right to health as a constitutional right. Nothing happened. Everything continued as it was before. 1994 was a watershed year for constitutional rights in Mexico. We established for the first time a true constitutional court. We went from 23 justices to 11 justices, and it was endowed with a tremendous amount of jurisdictional authority to adjudicate cases of constitutional law. And then 2011, we saw the a human rights reform in the Constitution, which was really foundational for Mexico. So for the first time, we started having human rights laws. Now, let me go back to 1917. The original Constitution has social rights, but it also inherited from the previous Constitution of 1857 very strong civil liberties. So there is a tension between civil liberties and social rights built into the Mexican Constitution. That explains, for example, the case in 2015 where the absolute prohibition for the recreational use of marijuana was declared unconstitutional. The health law established an absolute prohibition for marijuana, recreational use of marijuana. And in 2015, the court struck down that article of the health law. It stated that a right to privacy prohibited an absolute prohibition to the use of marijuana. So the court there had to deal with this tension between strong civil liberties and social rights. After 2011, we really start seeing the adjudication of health law as a truly constitutional right. Article 1 was amended of the Constitution to incorporate into the Constitution, much like the 14th Amendment incorporates into the states the constitutional rights, the federal constitutional rights. Article 1 of the Mexican Constitution incorporates into the Mexican Constitution the rights, the human rights, where Mexico is a treaty partner. And so that really creates a very strong network of human rights in Mexico, constitutional human rights in Mexico. The court, after 2011, I would say, started adjudicating cases, and I would say under 2 principles. First, it was a very strong rulings with respect to the minimum health requirements. I will give you a couple of examples. It adjudicated on tort law, the requirements for tort cases where there is where medical surgery is involved. Also, with respect to the minimum requirements for public health. Two cases that come to mind very quickly. A group of people who had HIV sued the state because there wasn't a specific area in a hospital for HIV patients for them to avoid having infectious diseases. The court ruled in their favor, and the government had to build the pavilion for HIV patients or provide them with private hospital care in lieu of building the pavilion. Also, municipalities began suing states for not building hospitals, which they had agreed to build, and we generally ruled in favor of the municipalities, obligating the states to build the hospitals in those issues. Where has the court been deferent? It has been deferent in public policy. The court will tend to defer to the administrative specialized agencies in health law on health issues. For example, a group of patients sued the Social Security Institute, demanding that certain medicines be included in the list of authorized medicines. The court did not side with them. The court said, the administration, we will defer to the administration to decide what medicines should be included, but the administration has to give the reasons why it will or it will not include those medicines. So it has been deferent with respect to public policy. Where has the court been shown very little tolerance? And it has been with women's reproductive rights. The court has been very strong in that area. We were discussing this in a panel this morning, and I said, Mexico went from Dobbs to Roe and not from Roe to Dobbs. In 2007, the Mexico City decriminalized abortion for the first time. And this decriminalization was challenged in court by the Attorney General. There was the government was from the right at that time, and they challenged the decriminalization of abortion. The case got to the Supreme Court, and the Supreme Court, my feeling is, I wasn't on the Supreme Court at that time, but my feeling is they wanted to declare the law constitutional. So they said it's a state issue. And they saved the constitutionality of the decriminalization of abortion in Mexico City. What happened next? Almost all of the state constitutions were amended to say that life begins at the moment of conception. This is a very Catholic country. And there starts a long, long march in the history of women's reproductive rights in Mexico. The first cases had to do with rape, and rape as a justifiable defense to the crime of abortion. And what the court started to do was take a very, I would say, aggressive position by saying hospitals violate a victim's human rights if they do not perform abortions in cases of rape. And the human rights violations include reparations and include the right of non-repetition. Non-repetition means you have to train your doctors and your nurses to identify these cases and to implement the procedure when necessary. Then came cases where the justifiable defense was health and health issues. And there the court really expanded the definition of what health issues are and when an abortion can be practiced or a justifiable defense can be used in order to avoid the crime of abortion. The court defined health as not only physical health, but mental health. And it defined mental health to include the right to choose, basically the right to choose. So that really opened the spectrum on women's rights, but it was still a justifiable defense within the crime of abortion. 2001, new government from the center is in power, and they challenge the constitutionality of the law that criminalizes voluntary abortion. So for the first time, the court really is able to center the issue and adjudicate on whether the crime of abortion violates the human rights, the human reproductive rights of women. And in a unanimous decision, the court struck down the criminalization of abortion. The next day, we adjudicated on the issue as to whether the states can establish the life begins at the moment of conception. And in a 10-to-1 decision, we struck down that three states that had been challenged, and we said that states cannot establish laws that inhibit, prohibit, or create a barrier to a woman's right to abortion. So we went from 2007, where we had said it was a state issue, to 2021, where we are affirming a federal constitutional right of a woman to choose and for her reproductive autonomy. The last issues that we're dealing with in the court that have to do with women's health rights have to do with NGOs that are challenging local laws that are still on the books as a crime of abortion. And the issue there is twofold. One is standing. We have granted them standing, even though obviously they are not, they cannot commit the crime of abortion, but we have granted them standing on a very broad definition of standing. And the second issue is relief. What type of relief do we give NGOs? And the relief we are giving NGOs is that we are obligating the states to repeal the laws that criminalize abortion based on these cases. So that covers about 100 years of case law in Mexico on health law, and I did it in less than 15 minutes. Thank you very much.
Thank you, Justice Gutierrez Ortiz Mena. And our final panelist is Justice Carla Andrade from the Constitutional Court of Ecuador. After her presentation, we will have a Q&A, so please start writing down your questions and passing them to the team, or send our questions in Zoom. Thank you.
Good afternoon. Hello, everybody. Thank you once more for the invitation. Thank you for having us here. It's been a great pleasure to share the different experiences that we have in our countries. Today, this morning, we were talking about health rights, but related to environmental rights. And I decided to change my presentation. I was going to tell you about health rights in Ecuador and the jurisprudence in Ecuador related to health. But I decided to talk to you about something that is different from other constitutions and that is unique in Ecuador. And it's related to health as well, but it's an indirect way of protecting health, and it's nature's rights. The Ecuadorian constitution not only has right to environmental rights in it, but it also has the natures of rights. And as you will see, and for some of you who have, this is not working, but yeah, there. No, the next one is just fine. I think not everybody's gonna be able to look at it, but the Constitution of Ecuador has a specific mentions to what nature, how important nature it is for Ecuadorians and for the country. And the Constitution declares nature as a subject of rights. This is a big change in protection matter. There is not, it is not an object anymore of protection. It is a subject of protection. And the Constitution has 3 different rights that relate to prevention, to restitution, to restoration, and to preventing the contamination of the ecosystems to make sure everybody gets the right, full enjoyment of the rights of nature. And how do we do this? It's not easy, because when you talk about nature's rights and its rights to prevention or to restoration, it was not clear where the limits are and how far we could go by asking for protection of the nature. So it's been part of the job of the Constitutional Court to give sense to all of this. And since 2019, perhaps, the Constitutional Court has been working a lot in these matters. And it's been an interesting evolution of how these rulings have been working. And you will see in this presentation that the first ruling the Constitutional Court addressed was related to mangroves. In Ecuador, shrimp is one of the main products of the exporting, the selling products of Ecuador is shrimp. And even though this is a really important matter in Ecuador, mangroves are exactly the ecosystem where the shrimp grows. So there was this complaint from the community related to rights of nature, not only about their rights. They were not only talking about contamination as an environmental right of the people, of human right, but the rights of the nature itself because of the intrusion of these companies to the ecosystem. In this ruling, the court decided that none of the constitutional rights can be absolute, but you have to find an equilibrium between natures of right and natures of the people and economic situation as well. So the court said that it's really important to preserve and to protect the life of the ecosystem. And it's the first time that the court gives nature's rights content. And it says like, it's not like the nature as a whole, but we can talk about different elements that the nature has, and we can protect all of those elements through the nature's rights. And ecosystems are part of those nature rights, and you can protect ecosystems through nature's rights. And it says that you have to protect the existence, the maintenance, and the regeneration of the vital cycles of this ecosystem to make sure they can live and they can stay like in the way they are supposed to be alive. And humans cannot be predators and that cannot be the ones who destroy it. They have to find an equilibrium to protect their well-being and the well-being of the nature. And this was the first time that the Constitution of Ecuador addressed nature's right in this specific way. A couple of years later, the court addressed new cases about forests, and used the same idea and said forests are also ecosystems, and we have to maintain this living ecosystem as it is, and we have to protect the structure of these ecosystems through environmental rights and as well as nature's rights. In these cases, we were talking about mining projects, really huge mining projects, and especially in one of the forests, the Bosque Los Cedros is the name of it. This is a really unique forest, and you can only find specific animals and plants there, and it was really, really important to protect that forest. If you see at the pictures, and you can turn around if you want, those are justices of the Constitutional Court of Ecuador. We went to the jungle to the hearing, and it was the first time we had a hearing in the jungle, and we heard the indigenous communities about the problems related to the forest and to the contamination of water and the mining effects. And in this case, the interesting part is that the Constitutional Court opened to new principles about protection, and they talked about prevention and precautionary principles. Prevention principle related to making sure that if you have certainty about scientific certainty about damage, you cannot go ahead with the projects. And if you don't have, and this is the precautionary principle, if you don't have that scientific certainty, but there's a risk, you should take it into consideration and stop any harmful activities to make sure you will protect the environment. So this was a really important and a really big ruling in matter of forest and environmental protection. And this was important because in this matter specifically, there's a COFANES, which is an indigenous community. The court said that all the contamination was actually harming the community in every way. They were losing their source of water, source of food, source of medicine, because the jungle is where they live and where they have everything they need to develop their lives. And this is the Bosque Los Cedros. This is the judgment. And then we came with a new ruling about rivers. There is actually 3 different rulings about rivers. And the court talked about rivers as part of a ecosystem. And this was a big change again, because the first time we were saying ecosystems are part of nature and you can use nature's right to protect it, the ecosystems. And now we are not in an ecosystem as well as exactly, but we are in a part of the ecosystem, and rivers are part of this ecosystem. So the court said you can also protect rivers with nature's rights through constitutional actions to protect these rivers, because the rivers and the structure and the functioning of a river, the cycle of the river is really important for the ecosystems and for people's lives. And water is not only seen in the Constitution of Ecuador as part of the nature, but also as a human right. We have a specific human right, is the right to water as a human right. And we have an environmental right to have environmental protection that also covers water. And then you have the nature's rights, where the court has said that rivers and lakes are part of the ecosystems and they can be protected through the nature's rights. So water, it's become like really important in Ecuador, and this is how we protect it. And this is really important in matters of health and in matters of production and in matters of food and other related rights. In this case, the court also analyzed the flow of the river, the changing of the flow of the river, how the mining processes or the agriculture are changing the rivers, and how it has to find an equilibrium to make sure that we can still live in equilibrium with nature. This was, as I said, 3 different rulings about it. And then it came the last ruling of the court related to nature's rights, and it was related to animals. In this time, we have a chorongo monkey. Her name is Estrellita. You can see the picture as well. And this is Estrellita. She was taken out of the jungle and took to live with a family. She lived like more than 9 years with the family in the city, in Quito. And after, and she had a lot of health issues because she was not in the jungle. And someone saw the animal, and the authorities came and took it away from the family. And what happened is that the monkey died. The family put an habeas corpus to try to recover the animal. However, when the hearing came, the animal was already dead. The authorities said that it was part of the difficult situation of the animal, but the family said it was the authorities' fault because they took the animal away from the only home she knew. And the court never said that the habeas corpus is the way to protect the animals' rights, but actually it says that animals are part of nature, and they can also be protected through constitutional rights and constitutional actions, and that Estrellita was protected by these rights, and she didn't only have like the three rights like I talked about, like prevention or restoration or whatever, but she could have also rights like integrity, life, and the court developed some new principles and some new elements of the animals' rights, talking about the integrity, the chance of being free, not being taken to the cities, respect for their way of living. And in the Constitution of Ecuador, we have a principle that is called the good way of living, the buen vivir o summa causa in indigenous language, and it's the well-being of living. And the court said that animals also have this good way of living. They have a right to this good way of living, and it's part of being free and being respectfully treated. And the court protected Estrellita as well. And since then, in Ecuador, we have it's been a really good change in matter of protection of nature. It's been different than before. The progress, the development of protection of nature is really big. And I would like to talk about before leaving, because I know that there's not many time left, but in the case of animals, the Constitution recognizes that in this equilibrium, not always we will be able to protect the animals like absolute protection. And it talks about hunting, fishing, domestication of animals, and even indigenous practices like related to symbolisms and other type of cultural practices. Because, for example, monkeys are the special food for special moments and for special parties. And the court recognizes that that might be possible, and that it has to be ruled in every case depending on the situation, but it recognizes that the Constitution has rights for everybody and that we should live all in harmony, even with the animal rights. And finally, related to water again, in Ecuador, water as a human right as well. It's been developed through, for example, this minimum vital amount of water that you need. We took it from the Constitution, the Constitutional Court of Colombia. They have this kind of way of ruling, and we took it from them. And in Ecuador, each person has a right to 200 liters of water per day. And the court has said that every time that someone like doesn't allow people to get enough water or quality water, you can go and address a constitutional action to protect your right to water. And that's because it is related to health, and it is related to other human rights. And that's the way we have been protected, not only as the right to health, the access to health, but also indirect by through protecting nature and through protecting water and protecting the environment. We have been protecting the health of the people as well. And that was the different approach I wanted to share with you today. I hope it's been useful. And any question you have, I can surely help you with some more information about it. Thank you so much.
Well, thank you very much to all our panelists. First, I want to say that we were intentional in asking you to talk about different topics or to give you the freedom to speak about a variety of issues, because here at the Center for Health and Human Rights, one of our lines of work is actually to study and analyze how different courts at the domestic level and at the international level will deal with health-related cases. So this exercise of comparative law that we usually and that we constantly do here at the Center for Health and Human Rights includes different issues. One is how health rights are provided for or enshrined in constitutions or statutes. The other one is what are the legal avenues to enforce those rights. we also study the different types of cases that different courts deal with domestically and internationally. What are the challenges of interpretation of evidence that courts have to deal with when deciding these cases? What are the remedies that courts tend to grant, both individual remedies or structural remedies? And what are the challenges of implementation? So I think that the panelists gave us an important overview about all of these issues. So thank you very much. We also here at the Center for Health and Human Rights study the common or recurrent objections to the judicial protection of health rights. Some of those objections are related to democratic legitimacy. Some other objections are related to the role of judges or courts in designing public policy, especially when that public policy have enormous financial implications. And also sometimes there are some other objections related to how the abuse of litigation on health issues may create inequity or equity concerns. So also, if some of the panelists want to reflect on these objections, we invite you to do so. And we are going to start with our Q&A. The first question that we have for each of you that want to respond is related to COVID and to the pandemic. And the question says that, well, COVID-19 addresses, among others, the importance of the right to health. And from your perspective, what is the role of constitutional courts in emergency context? You can respond to this question in general, or you can share with us if your respective courts had to deal with COVID-related cases during the pandemic or after the pandemic, in the order that you prefer. Who wants to start?
Okay.
So Justice Angel Cabo from Colombia.
Yeah, so I would like to reflect on your first question is about the intervention of judges in socioeconomic rights and especially in the right to health. Because I think the objections are common, but not necessarily true. I think, for example, can I switch to Spanish? Yes, okay,
Sure.
Es que me queda más fácil responder. Es que la discusión sobre si los jueces deben intervenir o no en cuestiones de política pública, creo que hay que mirarlo, no es si deben intervenir o no, sino cómo es la mejor manera de su intervención. Esa es la pregunta crucial. Y realmente si el juez primero, esto suena muy controversial incluso en mi corte que es, pero los jueces somos actores de política pública, sobre todo los jueces cuando estamos tomando decisiones que se relacionan con estos casos. Entonces, lo primero es asumir que somos actores de política pública, pero no somos los actores principales de la política pública. Entonces, creo que cuando uno piensa en cuál es la mejor manera de la intervención, yo creo que un juez que interviene en materia de derechos como salud, como lo hace la Corte Colombiana, cuando entiende que puede servir como una persona que, como dice Seibo Danzando, desestabiliza a las otras ramas del poder público para actuar o las empuja a actuar, está haciendo algo que es importante y no es menor. Entonces, pero lo que no puede hacer es tratar de sustituirlas. Nosotros no tenemos la información que puede tener el gobierno o el legislador en materias técnicas, no tenemos cálculos actuariales, no tenemos una cantidad de información. Y si nosotros quisiéramos resolver todos los problemas estructurales de la política pública, pues haríamos una pésima política pública porque no tenemos esa información. Pero sí tenemos, a través de estos casos individuales, la capacidad de por lo menos iluminar esas problemáticas estructurales que es necesario que el legislador y el gobierno traten de resolver. Por eso creo que es una falsa crítica decir básicamente que acaba con el debate democrático, la intervención de los jueces, etcétera, si uno realmente entiende que es la manera en que lo hace. Por eso, digamos, en la discusión que se ha dado en Colombia, ha sido muy importante la discusión sobre el tipo de remedios que pueden tomar las cortes y quizá esta idea de remedios suaves, de señalarle al legislador, corrija la política, haga una política sin decirle cómo, pero, vigilando que lo haga. Porque es que esto suena muy bien, pero realmente en nuestros países, realmente el legislador y los gobiernos han sido muchas veces muy pasivos en corregir estos problemas estructurales que en realidad generan un obstáculo para la población para acceder a sus derechos. Y simplemente en el caso de Colombia, pues tuvo un rol muy grande en materia de la pandemia, porque la pandemia básicamente se respondió con decretos de estados de excepción, de emergencia económica y social, y en Colombia la Corte Constitucional tiene que revisar esos decretos automáticamente. Entonces, pues fue inevitable jugar un rol muy grande en la pandemia.
Great, thank you very much. Someone else, yeah, Justice Amari.
So in the case of, well, personally speaking, I don't think the discussion about how much leverage or leeway has the constitutional court or the highest court of any given country regarding public policy. Of course, we can separate the issues of whether adjudicating cases on matter of principles, of legal principles, or deciding the cases on, on, under the parameters of opportunity and conveniences. Okay, we can separate those things, but at the end, the court will issue a decision and can make some arguments in order to base its decision on what the law says. And one thing that we need to accept more than ever as judges, justices, or actors in the judicial system is that our decisions will not please everyone. I mean, we are not pizza, we're not Coco, we're not, yeah, we are not gonna make anyone happy, especially with the government and Justice of this man can talk to us, Alfredo, that has some experiences that we talked this morning about the relationship between the executive power and judicial power. So at the end, it's never gonna please anyone. No, so that's the thing that we need to take care of. What we need to do, and that's something that especially Catarina Lagos brought up in one of our discussions, is how to make ourselves transparent in terms of our arguments in trying to justify the decision and trying to understand what we can or we cannot do regarding some issues of public policy. In COVID, for example, the problem that the court had in Dominican Republic is that the thing is that we made the decisions very late. I mean, we had the opportunity to review the actions made by the executive power and some other institution of the public administration regarding COVID. And we did. We issued a ruling, the judgment 441 from 2022, in which we declare constitutional a regulation of the public health ministry and the legislation declaring the state of emergency. And we decided that almost like 1 or 2 years after the COVID emergency. And so that's might be the problem, but we didn't decide the case in terms of dismissing it because of mootness, that is no longer a case of controversy being alive, but we decided that for the future. So one of the problems that emergencies, public health emergencies like the COVID, is that courts might be there too late in order to readdress the issues because of the public health emergency, especially in that case, COVID. Some other countries around the region had a better luck, but in our case, we came there like very late because how everything was just handled by the government, and people usually had more confidence with the government, how they handle the situation with COVID. But that didn't mean that lower courts had no job or no working or no work during those times. For example, the criminal jurisdiction had a lot of cases regarding habeas corpus or arbitrary detentions and so on. And also, since COVID was during the elections of the Dominican Republic from the 2020, The elections jurisdiction, well, unlike the US and some other courts in Europe, we have a special jurisdiction for elections. Everything regarding elections, we have a special jurisdiction. Conflict between parties, between political parties or within political parties, we have a special jurisdiction to deal with that. Okay, so, and during that time, all the protections of fundamental rights regarding health and political parties and political rights were duly protected by those courts. And since the people understood that it might take some time for the Constitutional Court to issue a ruling in review, most of the time they just accept the decision of the jurisdiction in the lower courts, because they say, well, we're not gonna have any more time to litigate this, so just let's accept the decision of the lower court. And that actually reflects a trust in the system. But what Justice Catalina Angel said, Natalia Angel said, it's very correct. Sometimes we're not gonna please everyone, but we need to assume the challenge that we are actors and our decisions will be part of the public policy, but under another lens that is different from the politician's lens in terms of public policy. Thank you.
Sí, a ver, hacer dos reflexiones. La primera tiene que ver con que el Tribunal Constitucional chileno no tiene competencias para conocer acciones de tutela de derechos fundamentales. La acción de protección, que se llama en nuestro país, es un mecanismo que está radicado en las Cortes de Apelaciones y la Corte Suprema, es decir, en el Poder Judicial y no en este órgano autónomo constitucional que es distinto al Poder Judicial. Por lo tanto, en la pandemia, la mayoría de los casos llegaron a las Cortes de Apelaciones y a la Corte Suprema, y hubo una serie importante de casos en que se presentaban estas acciones de tutela a propósito de las restricciones a la libertad de circulación, por el impedimento de ingresar a ciertos lugares públicos si es que uno no podía acreditar la vacunación de la vacuna del COVID, y ahí también se esgrimía la libertad de conciencia a propósito de lo que yo decía un rato, y en general las Cortes de Apelaciones rechazaban esas acciones de protección. Y en cuanto al rol de la justicia constitucional, como nosotros tenemos una particular conformación de nuestra jurisdicción y tenemos competencias muy específicas, no nos toca hacernos cargo directamente por alegaciones a propósito de vacíos o problemas en las políticas públicas en materia de salud. Pero les quería comentar que durante el proceso constituyente, el último proceso constituyente que llevamos adelante en Chile, que tuvo una propuesta constitucional que fracasó finalmente, dispusimos de mecanismos de justicia dialógica en el diseño del Tribunal Constitucional, de la Corte Constitucional, justamente para hacer frente a una realidad que estamos enfrentando la mayoría de los órganos que ejercemos justicia constitucional, que es esta necesidad, ¿cierto?, de poder dialogar efectivamente con quienes están llamados a diseñar las políticas públicas para efectos de no tomar decisiones y no sustituirlos, sino que generar un diálogo democrático, ¿cierto?, que permita tener mejores soluciones en el lugar que corresponda competencial o técnicamente.
Thank you, Justice Lagos. I will maybe add to the COVID question that also at the Center for Health and Human Rights, we monitored how courts reacted to COVID cases, and we identified like 3 different types of cases. One type of cases were related to the limitations on rights based on public health concerns, so the decreased limiting rights, what we all lived during the pandemic, and the constitutionality of those limitations. Another group of cases were related to access to diagnosis, treatments, vaccines in response to COVID or for COVID, for the disease itself. And in those cases, there were a number of discussions about allocation of scarce resources during the pandemic, during an emergency. And another group of cases were related to the specific situation of groups, persons deprived of liberty, or especially persons in different institutional settings, and the particular vulnerability of those populations during the pandemic. So we are we have been monitoring those responses. Most of these cases were decided after the pandemic, so this also brings another reflection on the efficacy of these decisions, but at least there is a number of precedents that can be used for future public health emergencies or pandemics. I would like to finish because we are about to be out of time. I would like to ask all of you to make a final reflection on efficacy and implementation. So what are the main challenges that you face when implementing your decisions related to health rights? And if you find that there is resistance on the part of other branches of government with respect to your more structural decisions, those decisions that have to deal with public policy. So if you can share with us the challenges in implementation and the relationship with other branches of government with respect to the judicial protection of health rights.
I begin? Okay. I think we do have a lot of challenges, especially when it comes to money. For the government, for example, in health rights in Ecuador, we have a lot of trouble implementing health policies because we don't have enough money. And for example, people are asking for medicines and quality treatments that are really expensive. And the government is constantly saying, I do have a limited budget for medicines, for example. And of course, there's a health right. And of course, you have a right to health and to get the best treatment. However, I don't have enough money to give the same kind of treatment to everybody. So if I buy the medicine you need, maybe other people is gonna stop getting their medicine. So the equilibrium is really hard to get. And the court in matter of public policy has been trying to be walking in a safe place because it's been really hard, and it's worse when we say that you should accomplish something and it's not possible to do it. And that's a backlash that it's worse than going baby steps in public policy. So the court is trying to do it in baby steps every time. The same happens when it comes to, for example, yesterday we were talking about people, the right to help in people who's in jail, and how they have access to health services and how they have to get the same kind of treatment that people not in jail have, because those are not suspended rights. So, however, for example, right now in Ecuador, government is proposing an amendment to the constitution related to taking people deprived of liberty out of the priority groups of attention in Ecuador. And that's because they are trying to say that people in jail are not supposed, and the people who committed a crime, they are not supposed to get the exact, the same amount of care that people out of jail. So it's been hard. It's always conflict, there's always tension. And the Constitutional Court is trying to make sure that rights are respected, that the Constitution is respected, and that people understand that we have to join forces to make sure that health in this case is accomplished as much as you can, as much as the state can make it, and as much as the resources we have can assure for people. So it's really hard. It's not easy, but we will keep fighting for rights in the Constitutional Court of Ecuador.
Thank you. Justice Andrade, Justice Angel.
Okay, so I'm just gonna refer to two academics of Latin America. One says, one uses the expression that we face the paradox of the social state. And the paradox of the social state means that in countries where there's more need, or there has more challenges about equality and poverty, are precisely those states that promise the most in their constitutions. So we have very, very ambitious constitution, but very lack of resources in order to address them. In anyhow, I think that promise still holds important because it's that what we need, and that's what people aim for. And another academic is Roberto Cargallá that says something that is called the Sala de Máquinas de la Constitución, or the, I don't know, machine room of the Constitution. But basically what he's saying is, again, that we are promising a lot. We have very, very ambitious constitutions, but our institutions are very weak in order to provide for those things. So I think not only lack of resources, but a tradition of very, very weak institutions is one of the main challenges of our country.
Thank you. Justice Gutierrez. Ortiz Mena.
Bueno, en México, pues hubo sectores durante la pandemia que se vacunaron a punta de amparos. Esa es la verdad. La Corte ha sido muy deferente y es deferente con los órganos electos, salvo cuando no se cumple con un piso mínimo. Y cuando ese piso mínimo no se cumple es cuando la Corte o los tribunales empiezan a otorgar amparos, como en el caso de las vacunas. Por lo general, sí se cumplen los amparos en México hasta hace muy poco. En materia judicial, no, pero en materia de salud, generalmente hay un cumplimiento razonablemente bueno de los amparos. Pero nuevamente, el amparo que se otorga muchas veces es para que la autoridad dé sus razones y motive la negativa o motive la razón por la cual está actuando como esté actuando. Es decir, hay un diálogo entre los poderes que exige que se den razones de la política pública. Lo que no ha permitido los tribunales es que no se den las razones de la política pública. Entonces, la motivación de la actuación se vuelve fundamental para efectos de los tribunales. Vale.
Thank you. Justice Lagos, do you want to make a
Sí,
final comment?
bueno, nosotros no tenemos esos desafíos como tribunal constitucional porque, bueno, nosotros decimos que una norma es inconstitucional y puede tener efectos generales y se publica, entonces es obligatorio, básicamente nadie puede eludir una declaración de inconstitucionalidad que nosotros hagamos en términos abstractos, y en términos particulares, bueno, los tribunales en general acatan nuestra resolución, entonces no tenemos ese problema, pero sí vemos los desafíos que tiene la Corte Suprema, ¿cierto? Cuando ha dictado, en el caso, por ejemplo, las instituciones privadas de salud, previsionales de salud, de seguros de salud, en nuestro sistema mixto que es parecido al colombiano, cuando han dictado sentencias exhortativas, ¿cierto?, para corregir ciertas cuestiones del sistema de salud, pero ahí hago mías las palabras de la magistrada Ángel Cao, porque efectivamente ya tenemos un diagnóstico sobre las deficiencias de nuestros catálogos de derechos fundamentales tan robustos y que no vienen acompañados de una orgánica, ¿cierto?, que permitan justamente garantizar esos derechos en la práctica.
Thank you. Justice Reyes.
Well, I think about constitutions as a developing plan of any society. It's a social compact to develop the society and where we want to be. Thinking about a utopia, right? Just like Eduardo Galeano said, I think he was quoting some other person, but utopia is that thing that you keep walking in order to catch it, but it gets a little bit further and you just keep walking. So the Constitution is something like that. So I do not get bothered, but I actually loved when constitutions are actually kind of long or has a lot of things, because it's just a compact in order to do things and to set the foresight where we want to be. Nevertheless, we need just to keep working on education and the political culture in order to get things going. And here I can say that about the Constitutional Court of the Dominican Republic, we try to see when we just adjudicate a case and we rule in favor of a party, and it needs to get something done in order to protect the right. We try to see what we can do within the existing remedy, and that's something that can happen within our reach. That's the first thing we look at. And if it doesn't work, we'll just keep looking that through another ways. For example, we hold meetings in order to try to get the enforcement of the judgment, or we try to, instead of ordering some equitable remedies of doing, maybe we can put some remedies in order to stop the doing, like stop a conduct in order to protect the situation or protect the right. Trying to figure something out. And in some other cases, we just take into account some legislation and we order some kind of like a fine if it's not paid, but also if it's against a public institution, take into account a very obscure legislation. We just order for that fine to be included in the budget of the institution for the next year. So that's why we just can try to circumvent the long proceedings of not doing nothing, but trying to take advantage of some secure proceedings that already exist in order to get the effective enforcement of the judgment. But again, we as judges, as justices, the problem that we have is our judgment do not work unless there is a will. And what we can do is instead of doing nothing, we need to keep doing until somebody hears. And that's the good thing about elections. Some new people will come in, some other people will go out. But I think the hope is part of our job. If we do not some kind of hope, then we have nothing. That's for sure.
Thank you for your final comments. We are convinced that while the judicialization of health rights brings enormous challenges to everyone, the focus should be on how we overcome those challenges instead of narrowing or limiting or abandoning the role of courts. And actually, courts in Latin America have shown that the balance between judicial activism and judicial restraint and deference is possible with respect to health rights. And thank you very much to everyone, our panelists and our public.
Can we bother you with one last picture and also mention distinguished panelists that joined us, Magistrate David Garcia Sarubi, Professor Sofia Charbel, and Special Law Clerk Beatriz, if you could join us for a last picture of all of you. Thank you.